Great. Happy, happiness. Yeah. I was talking to Happy, and she told me uh, that she's named after happiness. Yes.
Yes. So, Peter, confirm you can see my screen.
Yeah. It's loading on my end. Maybe it's loaded elsewhere. Yeah. Yes, we can
Okay.
see it. We can see it.
Thank you. Thank you,
Yeah.
Maurice, Peter, for hosting this webinar. So thank you, Maurice, for the introduction. And without further ado, let's just go straight to what estate planning is all about. Um, so this when you hear about estate planning, it's about wills, it's about the probate process. And here the probate process is that process where if somebody has passed on and there was no will or a trust in place, then the relatives, you have to apply for letters of administration from the court and get a listing of all his assets or all her assets, get to the court for either distribution according to the family's agreement, or then the court will distribute the same. So that entire process until you get a grant of probate, that is what is called the probate process. Then we look at what estate planning essentially means. It's about guardianship. This is where you appoint someone to take care of your kids who are below 18 years, because in this country, majority age starts at 18. So without an ID, you can't transact. And then we look briefly at what trust is all about, because this is fairly a new concept in the country, but not a new concept in the world. So just to bring it home so that you appreciate why each and every one of us needs to have an estate plan, I'd like you to answer these questions. If you have defined what your legacy is or what success is for you, I'd like you to answer that yes or no. Do you have a will or a trust in place? Yes or no. Is your marital status well defined? And I know here I get a lot of people saying they've lived for many years. This is my wife, this is my husband. Society knows. Yes, that they know until when things go south and they have to go to court for um, judgment, and you'll be surprised that you will not be recognized as a spouse. So for all relationships, there's always a document that defines it. If you have a child, you have a birth certificate, you have title deeds for your houses, for your land, you have a logbook for your motor vehicle. So for marriage, you need to have a marriage certificate, and even if you married traditionally or customarily, from 2017, it was decided that even those customary marriages, which yes, the law recognizes that they are potentially polygamous, must also be registered. So you go to eCitizen after 3 months of having performed your traditional rites of marriage, and then you apply. Then after 7 days, you will be called at the ages office of the registrar of marriages, and you will register. So even if you have 3, 4, 5, whatever number of wives, you need to have them registered. So in that sense, that presumption of marriage stopped existing as at 2017. So is your marital status defined? Have you defined all your beneficiaries? And this also gets interesting because for some reason, we have that incorrect understanding that beneficiaries is only your spouse and children. But there are those people that we support on a regular. So those are also your beneficiaries. And it is also interesting to note that beneficiaries would include entities that you support, charities, churches, the schools that you support, all those are beneficiaries. And the purpose of defining them is because when you die, it doesn't mean that all those people you support are going to die with you. So how do you plan for them? Because you need to start something that you will finish, and in that sense, then we need to rethink our ways of helping people. Are we helping people so that they become independent, or we are helping them to to enslave them to depend on us. So have you defined your beneficiaries, yes or no? And do you have an inventory of all your assets? Not in your head, but somewhere where if you die, then your people are able to get that list and know where all your assets are. Or do you want them to get lost because your people don't know and then you get to lose them? So have you defined, is your next nomination of next of kin updated in all your records? Or when you get those insurance reminders, your administrator reminders, you throw them into the garbage because you don't want to, you throw them to the spam, you don't want to address them. So out of all the 6, how many I'd like to see in the chat? You could put that as we go along. What is your score? Do you have 6 out of 6, or what is your rate? Surprise me. I want to see if there's someone who has a 6. So we look at then what is why do we evade, or why do we avoid this issue of estate planning? One, because generally most of us say it's premonition of death, but then the question is, premonition or not, death is, we'll all die. No one is coming out alive. So, and we keep saying that this world is not our home. So if that is what we believe, then our actions need to align with what we say. So premonition or not, then I think it's better if you plan, if you die planned than unplanned. There's a book by a certain author, I've forgotten her name. She was a nurse for over 20 years and she wrote the 5 top regrets of people at their dying point. And one of them is that they wish they had time to put things right. So now that you're here and now you have the opportunity to do that, why not do it? So that you don't care what happens after you die, which is not really true, because we are the same people who admire certain families that they are good families. So why do we admire those families that in our perception we say they are good families? It's because they're planned. It's not accidental. It just doesn't happen. Somebody somewhere took time to ensure that their legacy is defined and that it lives beyond them. That you do not need a plan because your family will do the right thing. That goes without saying. We know that doesn't happen anymore. Family is the one that most of the time actually doesn't do the right thing by you. In my experience as a trust fund manager, I can tell you that 95% of the families do not do the right thing. So take it upon yourself to ensure that you put down exactly how you want your family to be managed. That your spouse will inherit everything, we know vitu kwa ground ni different. It also doesn't happen. We know of situations or circumstances where if somebody passes on, your immediate family, in fact, your siblings are the first people to come to your house to say, "Hizi ni mali and wetu." We've seen that so many times. So it's not that obvious. And that estate planning is for the rich. The question is, do we have an SI standard of rich, such that when you reach this point, then you categorize yourself as rich? And then the other question I like asking is, if you die, will your family fight for the neighbor's assets or your assets? So iyo yako kidogo, that is what you need to plan. You own something, however small, that is what you own, and that is what you need to properly transition in your family, because your family will not fight for the neighbor's assets. They will fight for those assets, however small. Then probate process will apply. For those of us who have gone through this process, you'd attest that it is not interesting. Legally, it's supposed to be around 6 to 8 months, but we know vitu kwa ground is also different. There are those people who had probate process taking even more than 10 years. So it's not interesting. So for anyone who claims that they love their family, do not subject your family to the probate process. So take it upon yourself to ensure that you put a plan in place. So what is this? When you look at when you don't plan, this is what would usually happen. I don't know whether sound is playing. Peter, please confirm. There's no sound.
Not yet. No sound.
Let me reshare again.
Yes. Yeah.
Is there sound now?
Yes.
From that short clip, you can see all ages are represented and they all reacted the same. And I can confirm that from my experience as a trust fund manager, that when money is put in front, imagine it does not discriminate how the elderly, how women, how men, how young people behave. They all behave the same. So that is just to show that if you don't plan, you have no idea what your family will turn out to be because money has a way of changing people. So just the same way that family behaved, it is exactly the same way families behave when there's money and there's no system or mechanism that has been put in place. When you think about it, even in our organization, we have HR manuals to guide our conduct. We have ISO or QMS to guide how we do our work. We have policies to manage everything so that we behave in the way that an organization expects. So why is it that we do not do the same for our families so that then they behave in a way that is aligned to your vision as a leader of that family? So looking at, and this is not because of the amount of money that these families had, but it's because they are public faces, and you can read and confirm the stories for yourself. Um, Looking at these families, look at how long these matters have been in court. So is that the kind of legacy you want? Looking at the story as at 2021 for the unclaimed financial assets, you can imagine they had 241 billion. And as at then, they only had received 6,000 claims, which amounted to 1 billion. So the mathematicians on this call, if 6,000 claims is 1 billion, then how many claims would make 241 billion? So that is the number of families who are suffering, who are not able to get medical attention. Maybe they are just out of their houses. They are not able to go to school because the family didn't know. Remember, I said, do you have your inventory out so that if you do not have it listed, so that your family would be able to know where to get the assets, then it might probably end up at the unclaimed financial assets. So the question is, even if you say you don't trust the spouse of yours, that's why you cannot disclose all that you own. Why are you doing this for the unclaimed financial assets stuff? Is it better that it goes there or better that it goes to your spouse, this untrusted spouse of yours, because it will end up helping your children? Or do you want it to go to this authority? That is for you to answer. So looking at how that is, if then you don't have a plan in place, then the court will distribute it according to this. Because we say if you don't have a plan, then the government has a plan for you. And the government's plan is that if you do not have a will or a trust in place, then using the Law of Succession Act, the court will distribute your assets in this order. So this first option is consanguinity, which means related by blood. So it would start with the first degree, which is your spouse, child, parent, then goes all the way to the fourth degree. And just from the look of this list, then it would make you understand why when people die, then other people come out to insist to say that they were dependents of this deceased person, so that then the court will find it to give them a share of the estate. So you'd see from this listing, first degree to the fourth, who would not be covered. So if you really want to insist to get a piece of this estate, you just have to prove that you are dependent, and the court will give you something. So that is why when people die, then you see all that drama. And if by any unfortunate incident that the deceased person does not have a blood relative, then the court would use this affinity, which means related by marriage. And starting from the first degree, that would mean your surviving spouse, and all the way to the fourth degree, which includes all that listing. So that is how the court will distribute. And at that point, remember, you're dead, you have no say into what the court will think, and it will be dependent on how those defendants are proving. And remember, our court legal system is based on evidence. So even if they fabricate the evidence and it is believable, then the court will assign. And you as a family will be wondering, who is this uncle, who is this niece that we've never seen before, but they come up at the last minute, or who is this other family that is alleging that they are our maybe half sister, half brother. They will be acknowledged by the court and they will be given. So as a prudent person, as a reasonable man right now, why not put a plan in place so that then you actually safeguard the interest of your family? So we've seen what lack of estate planning, the disadvantages of estate planning, not planning your estate. So what then is estate planning? What should you do? Estate planning simply means you preserve, you manage all that you have worked for, and you distribute it in a manner that is suitable to align with your vision, because you are the one who knows your family, you know who can do what and who is good with what. So how then do you distribute it so that you maintain the peace? So in short, that is what estate planning is: preserving, managing, and distributing. And for you to have all the necessary components of an estate plan, you need to have these three things. One, the asset, which means it's like pinning the asset. That is how I would say it. How have you pinned your asset such that if I'm looking for this house, I will know it is this house and not the neighbor's house? So you need to be as detailed as possible. If it is a house, which county, which estate, which house number, which street, which registry LR number, all those, so that when somebody is tracing these assets, they will not confuse one for the other. Even if it is a car, where is it? Where is the title? Is it still charged with which facility? If it is maybe in the public transport, which organization, who's the person who, contact person, like if, let's say, for example, Molo line, who's the person that you need to talk to, what is their address? So that way, then someone who's tracing your assets will actually get to all your assets without trouble. So how do you pin your assets? The second thing is purpose. Why are you setting up this trust, or why are you writing this will? So what is your pain point, or what is your vision that you're trying to pen down? So it could be your vision, it could be a pain point that you're trying to address. So what is it? So what is the why and the why, and then how do you want to address it? Then finally, the beneficiaries. And I said here it could be individuals, it could be the other people that we assist, it could be corporate entities. So who are they, and when do you want them to benefit? What is the frequency and what is the amount? So this is how you identify your beneficiaries. So in whatever way you're choosing to do your estate plan, you need to identify all your assets, you need to know why you're doing it, and finally, who are the beneficiaries? So when you critically think through about the people that you usually assist, who are they? How often do you assist them? To give you an idea what an estate plan would contain, it is everything that you call an asset. And you can see from this one, you even have clothes, you have photographs. So anything that is valuable to you, anything that in your definition falls as an asset. So the list is endless. This is just to open up your mind what can go into an estate plan, but the list is longer than this. This is just to give you exposure or an insight. So looking at this country, we have two instruments of estate planning. We have wills, which most people have an idea what that is about. And then secondly, we have trusts. So we start by wills. What are they? One, it is the simplest form of estate planning. And the key thing to note that wills only come into effect after you die. So there's no way of testing concept for this. And it is usually kept a secret until you pass on, then the will is read. So much as then it is, you don't give this to your beneficiaries, you are supposed to be communicating what your intention is so that when it is finally read to them, it concurs with what you have been telling them or what your actions have, that they align. Don't think you will use a will to surprise your beneficiaries after you die, because that is why when you see a lot of challenges in court of the will, because it seems to be contrary to what they expected, to what they thought your plans were. So it has principles of writing. One, that it has to be written. And yes, even oral wills are valid, but the caveat for oral wills is that you then need to die 3 months after pronunciation of the will, except for the people who are in the armed forces, because when they go to war, you have no, you can't determine when they'll come back. So apart from the armed forces, if you as civilian make an oral will, then you need to be sure that you'll be dead within 3 months. If not, then it becomes nullified. So yes, because most people say, but see, I can do an oral will. Yeah, that is also, you need to know, if you're insisting on an oral will, then you need to have that fact in mind. Then it needs to be witnessed by 2 independent witnesses, meaning that these people who are witnessing the will are not beneficiaries in the will. Because if you do, then you have to get 4 other people to witness, which now makes it a crowd. So just get people who are not benefiting from the will, and preferably that they sign that will, the witness that will, in front of each other. Then you need to appoint an executor, preferably a lawyer. I did not say must be a lawyer, preferably a lawyer because of the technicalities of wills involved, but you can get anyone as an executor. Then there will, one of the reasons why I said preferably a lawyer is because a lawyer would know that these 6 assets do not transition through a will. Even if for those who have sought letters of administration, you will notice that the court will strike out these assets if you have included them in that period, that stage where they ask you to get all the assets of the deceased. Reason being that these assets are properly provided for by the statutes that enact them on how to nominate your next of kin. So you'd see your life insurance, there is a place where you have to nominate your next of kin. And that is where I find it interesting that, because insurance company, pension administrators, annually they would send you reminders of if you want to update your next of kin, but we throw those things in the spam. But the implications of these decisions that we make, which I say it is being reckless, sometimes have very great adverse impact on our family, because sometimes you started working when you're single, you're now married, and you have never updated. So when you pass on and your spouse realizes that they are not the next of kin, it is your parents, you can imagine what that means in that relationship. So your kids have lost 2 people in one stroke, because then they will not be friends anymore. Because the other person, your parent who's the nominated, would think the reason why you nominated them is because there's something wrong with your spouse, or, so there's a lot of suspicion. So for all these assets, do you have the people that reflect your current status in life? Maybe you are married, you have since separated or divorced, but you have never updated. You put your sister, your elder sister, they've since passed on, or your parents, and they've since passed on, you have not updated. So do the nominees here reflect your current life? For bank accounts, it's good to approach your bank and ask them for you to execute a document that would say, this is a person that I'd like to get my money after I die. For the properties which are held in joint tenancy, this means that if you pass on, then the property reverts to the surviving people. So if you're holding this as a chama, that is why it is important knowing how you're holding your assets. Then you should know that this does not transition to your beneficiaries, but to the surviving owners, the people you own that property with. So if it is a chama, then the best way to own property is through joint tenancy in common. So for tenancy in common, then your part of the share of that asset would transition to your beneficiaries. Also for wills, it's good to know that it has its challenges, it's expensive, it is formalistic, there's rules to how to put it down. You can't choose which judge to listen to your matter. And remember, judges are just people like us with their exposures, with their biases. So you can't choose who your matter will be placed before. Some decisions that come from court are in direct contravention with our traditional customary practices. It may not be very flexible because our legal system as well is based on precedence. So you'd look at what a previous matter with similar circumstances, what was the ruling, so that then you align. And that is why you'd find two matters which are very similar, but the decisions are it's north and south, because even the judges are people with their biases and the exposures and their own different personalities. Reputational, because courts are not are not private places, so anyone can go in. And by the time a family is in court, they're not saying nice things about each other, so all your dirty linen will be in public. If you commit suicide, so please do not write a will and plan that you're going to commit suicide, because that nullifies the whole thing. The designated assets we've talked about. It needs a lawyer, because for assets which are above 20 million, then it needs to be filed in a high court, not a magistrate's court. Then we said it takes effect after you die, and tracing of those properties, if you do not have an inventory, is very challenging. And that is how we lose most of assets. I'm sure you know of assets where maybe the person died and no one has taken it. It either gets into strangers' hands, or it just depreciates and rots away because the family is not aware. And the reason why estate plans fail is mainly because of us, who are the family leaders. You do not communicate what your vision is, so your spouse, your children have no clue what your plans are. You don't train your children how to manage money. So much as it doesn't matter the amount, even if it is 10 million, research shows that 18 months that money will be blown away. Technical reason, that is to the advocates. Then lack of a wealth mission, that is still you as a family leader. What is your vision? For our organization, we have those mission, vision statements. What is ours? What is yours for your family? So if you don't, and maybe that is why our organization are not as successful as they should be, because we are doing things which we don't even understand from a personal point of view. So if you don't have a wealth a mission for your family, if you don't communicate what your plans are, so what are you doing? Doesn't make sense. And even from the book, those ones who are Christians, in Habakkuk, it says, write your vision. If God has said, write your vision so that all who read can run with it, it is because there is something about writing, then we all understand it from the same perspective. You cannot say, I have it in my head. It is good. It's not good enough to have it in your head, but you need to write it down so that it also makes you see clearly what you're planning. So we look at trusts. This is a tripartite relationship where you have the truster, grantor, or settler, meaning the same thing, that is you, the client, or you, the person who's setting it up. The trustees are the people who are going to manage it, and the beneficiaries. And we also have an executor. This is the person who's the in-between, who is the person that the trustees and the beneficiaries all is the liaison person between the two entities. So it's a tripartite agreement, a relationship rather, and it has its advantages, which in my opinion, outweigh wills, but I'm not saying wills are bad. You just need to know which assets to transition through a will and which assets to transition through a trust. So one of the advantages is that it avoids probate process entirely, because for wills, even if you have a will in place, you still have to go to court for validation. But for a trust, then that is not a requirement. Very easy to set up, because you just need to sign a grant letter, which is a set of instructions for how you want your family managed. So this is where I say you as the family leader, this is what you write what you're doing now, just put it in paper. Exactly the things you're doing to your family, put it on paper. Then it is the only way that you safeguard the interest of the minors and the vulnerable. Because in families, we have those people who are very eloquent, very vocal, very pushy, very bold. They will they may disadvantage those ones who are weak, like maybe you have, especially for the parents who are poor, they also don't have voices. So the vulnerable will be disadvantaged. The minors have no say. So it is the only way that you safeguard the interests of the minors and the vulnerable. It gives you the anonymity, because I say life happens. We have men with families that are not known, but they exist. We have women with kids that are not known, but they still exist. So it's that anonymous status will be status quo if you choose to set up a trust and provide for them the same way you're providing for them right now. Then funds are invested by a fund manager. If your will is with an advocate, there is nowhere where they're required to give you plus interest that has been accrued over time. But for trust, this money is invested, and you will see it in your statement for the year. I mean, for every year that an audit is done, then you'd see the investment income that you have earned. You can use a trust to make a gift take effect in future, like for your grandchildren. Even if you don't have them, you could provide for them. Even if you have them, you could still provide for them, whichever way. Then, because it is managed by administrators, then it means that your family disputes are managed to a minimum. It also gives you a framework to provide for beneficiaries who are not family members. For charitable causes, and this is also how the Nobel Prize came about. So in providing for either you reward beneficiaries who are outstanding in certain ways. That is how the Nobel Prize came. So you could do the same for your family, so that you motivate them to do what you know is right, and knowing what their potential is. That is the way you can motivate your kids to do that, which they have the potential for it, but they need that little push. It is cost effective because it earns an investment income, and you have to pay for the services, and it is not that much. It preserves wealth. So for those parents who maybe you're seeing your kids are getting into companies that you really don't quite approve, but there's nothing you can do about it. If you put your assets in that trust, then it would not be subject to divorce proceedings, either from you as a settler, because much as you've been married for quite a while, divorce doesn't choose the age. So even if you divorce, then your assets would not be subject to marital divorce. Even if your kids divorce, then they'd not be subjected to that. So that means your assets are protected, even from creditors, from litigious malpractice, if at all you fall into one. Maybe you're a business person, so chances of you being sued for litigious malpractice is there. There's that chance. So if your assets are in the trust, then that will not be touched. The other, just the same way we started with families that are in court for years and years on end for fighting over distribution of assets. It's also good to look at also the families, and I insist, it's not because of the amount of money, but because they're public figures. You can identify, you can research, you can confirm for yourself. So looking at these families, you've not heard that the children are fighting because of assets. And before you say it is because they have a lot of money, we have Tuskies, we have Nakumat, which were families with big money, but where are they right now? But these are that way because there's a trust in place, not because their kids are not special. They are the same kids. They are just like you and me, but because there's a constitution in place to run to how you utilize the family assets, then they are orderly. So it's much as you say the way we admire those big families, it is not that the grass is green on the other side. You water your grass and it will be green. So take action today to ensure you plan for your family, so that then they leave the legacy that you have, your vision aligns with your vision. Looking at one such example, you can see that bullet 1, 2, 3, 4, 5, where he says that wealth to flow along the bloodline, but not his children, spouses, or life partners. He's very specific. So if as a person like this can do that, that's why I'm saying it is not accidental, it is not coincidence. Somebody somewhere took it upon himself to put it down in writing so that then their families are protected, even posthumous. So take charge now. Don't think that, and I'm not diminishing the power of prayer. Prayer is good, but over and above your prayers, you need to actually put down your vision. We don't run our organizations with prayers year to year. The same Christians who are working those organizations. So the same way you have pinned a vision for your organization, you have ISO certification to manage how people work, do the same at a small level from your family, at that family level. Saying that and not giving a solution is not helping. So this is how we have provided assistance, a solution to that problem. As we say, CPF, we are a group of solutions. So this is a solution we have for estate planning for those people who are keen. We are properly registered. That is our KYC doc. You can check us out. We have this governance structure where we have a corporate trustee who is the apex decision makers. We have the the administrators, that is where I sit. Then we have the settler, who is you, and welfare committees for, we also have a solution for affordable last expense, because we are trying to minimize this issue of WhatsApp contribution for funerals every other day. And the reason why we have service providers is because this provides a maker-checker solution, because as of now, we don't have a regulator for trust, and it is normal because laws always come after a practice has been established. Even when you think about the RB, it came in place in 2007, and I'm sure you know people who started earning pension way before 2007. So laws usually come into place after practice has been established to ensure that there is fairness and justice. So the reason why we have this is especially because we give the assets go to the custodian, and the importance of knowing what the role of a custodian is that they safeguard the assets in the customer's name, not the bank's name. So even if the bank would go down, your assets would not go down with the bank. So that is one of the assurances or the comfort that this arrangement gives us. The fund manager invests prudently. We have bankers and an auditor, external auditor, to ensure that your instructions are carried out to the T. So this is his statistics to just show you. We are at about 1,000 clients. These are 840 families. We have around over 6,000 beneficiaries across the world where we manage them. This is our fund value, 1.3 right now. This is a payout we've done. We are having 14 groups. Just to have a feel of what some of our clientele looks like. This is on the corporate scene. These are some of our clienteles that we have. So even as a corporate, you can start up a trust so that you manage the welfare of your staff who pass on and they have kids. So you could set up also a corporate trust for your organization under the member trust fund. For welfare, what I was saying, to affordable last expense, you can see the blue line is premium. So especially most people take this on for 100,000, which you pay 3,500 per annum. And the package covers a member, spouse, parents-in-law, and 4 children. So this is really affordable. It would then eliminate the need for those frequent funeral expenses that we have through our WhatsApp groups. So what is the mandate of the small? Yes.
Happy. We have run well out of time.
Okay.
And we had the questions. There are few people who had set up questions. I don't know whether we are going to get time to, because we've got to close at 8:15. We have 10 minutes.
Okay, that is our mandate. You can set it up to take effect when you die, or you can set it up. So we have a living trust and a testamentary. Testamentary is when you die, but it means you set up your instructions now. or you can do a living so that you test the concept. It's very easy to sign up. You give us your documents.
Such a statement.
There is no use.
It is because you manage the different personalities in your family, and that is why we usually have fights. Those are our value proposition. Most important is it's the fees that we charge is 1.5 per annum. So that is why I was saying it is affordable, and I bring it to a close. You can read the questions. Then key is if you know people who need this service, reach to us. We can talk to them. We need to spread this as far as it can get so that we minimize the drama that we usually have. Thank you, and sorry for overshooting my time.
Great. Yeah. I know sometimes when we start speaking things we love, it can it can be sweet. Now, first question from David Ndolo: how early should conversations around estate planning begin? How early?
Early as you own anything. So it is not that misconception that you have to be old is really, really wrong. I don't know where that came from. As early as you start owning anything.
Great.
So
Number two from Liz.
From 18.
Oh, okay, 18 years.
Yes.
From Liz Wenzao, good morning. Why is it that the process begins with confirmation from the chief to prove your parent was your parent?
Yeah, it is because you were reckless enough not to plan, because if you did, then that would not be there. And that is why I said probate process is really a mess. So why would you subject your family to that, knowing that that is what it costs? Then take it upon yourself to put a plan now, because if you do, then that is not, I mean, it doesn't happen.
Great. The second part of that question was, what are the implications of witness the administration process? I don't know. What are the implications of the witness?
No, for a
I don't
will,
know whether you get that. I don't seem to get
let,
it.
I'm not sure also get it, but for a will, you need witnesses just to witness that you wrote that will. When you're sane, when you're of sound mind, you are not coerced. So that is the implication of witnesses. But as I said, they should not be beneficiaries in the will.
Okay. John Rajwai asks, thank you for this informative session. Please clarify the issue of next of kin indicated in the bank insurance against legal administrators when one goes to Sayun. Whether it's true that those listed as next of kin are just meant to be informed to enable the legal process starts.
For those 6
In other
assets,
words, I think, is it the last, if you mention them, that is just the beginning. It will not be that they are going to be awarded or something like that.
No. For insurance, for pension, for your SACCO, the person you've nominated as a next of kin is a person who would be paid your benefits. And for your information, you would not challenge that in court because, as I said, they have statutes that provide for how you nominate. And that is why you're supposed to review your plans every time your life changes, you're supposed to review it to align. So the court will not listen, and the people who are managing that asset would pay. The last nomination on your file is a person who would be given the assets.
From David Ndolo, I think we'll just try to answer this to shortest possible. From David Ndolo, in the last 50 years, might there be data available on how many Kenyans die intestate, and the overall impact that this is socially and economically to the country? What is the impact to the country? Is there something?
You just need to go to the unclaimed financial assets. That would be one good indicator of how, looking at 241 billion not being administered in the way that the people who held those assets would have wanted. That is a good indicator. And as I said, we don't have a regulator for trust. So I am not sure whether you'd get that that kind of research. But for me, looking at the unclaimed financial assets, it's one of the authorities why would it exist if we are if we are organized at the family level, that is a reflection of our recklessness as a country.
Last one. In the case of a family trust signed by a parent with his children, can this be used as a will? Who qualifies as an administrator of the estate?
You can't mix wills and trusts. Wills are different. Rule of planning and trusts are different. So a trust, yes, the parent will sign. There are trustees who will run that family as per the instructions in the grant letter. But a will, you would have your witnesses, and the advocate would then validate the same in court and read that will in the presence of all the beneficiaries. So those are two
Thank
different
you.
ones. Yes.
Yeah, there are very many questions again in the chat, including from Georgina. Georgina is from Tanzania currently. She's even asking whether you provide the same for international clients. And I know there are a few other people who will be interested. So please, you can put your contact there. I know I'd put your website, whatever. You can put your contact there so people can ask you further. At this moment, I think we have to bring it to a close. Noel, you can put the contact in the chat, then they can just copy.
Okay.
Yes. Noel, who is doing vote of thanks?
Antonia.
Antonia, come on.